Yesterday first, I called for jury duty. So why am I here today? So it was actually kind of annoying. I really want to serve. I've never actually served before. I was actually looking forward to it. So they called me to the Harris County Court yesterday around 3:30 or 3 o'clock. I show up. They have to sit there for 5 minutes. And they say, okay, we have no more trials. Go home. So the way trials work in state court is a trial lasts an average 30 to 45 minutes or an hour maybe. So all the trials that were scheduled for that day either settled or finished before 3. So I was promptly sent home. So I was actually saddened by that. I really wanted to serve. I was almost positive that I'd be struck from the jury because I don't know why any lawyer would let a law professor onto a jury, because I will tell them what the law actually is, not what they're saying it is. I'm not supposed to do, but I would do it anyway, probably. But I did not make it through, so I was very saddened by that. So close, but no cigar. Okay. Questions on class from last time, on Buck v. Bell, on Meyer, on Griswold v. Connecticut, on substantive due process. Any questions, anything on your mind? No? Okay, we'll move on then. So our discussion today continues our focus on substantive due process. And it focuses on the 3 major abortion precedents that the Supreme Court has addressed. There have been others which I haven't assigned, and again, if I had more than 4 credits, I would assign, but unfortunately we don't have time to do everything. But these cases establish the basis for how the court has approached the topic of abortion over the last, I guess, 4 decades or so. I want you to think about these cases as something of a continuity. Notwithstanding Casey's admonition that we are reaffirming the core holding of Roe, which I said over and over and over again, they weren't. Indeed, the doctrine was modified from Roe to Casey. But I want you to think of the progression in this fashion. So we had, the so-called Lochner era, where the court was supposedly using the due process clause to invalidate laws that conflicted with their own views of what should be morally and socially acceptable. And then we had the New Deal and the switch in time that saved 9, and West Coast Hotel v. Parrish, in which the Supreme Court said no longer will we invalidate laws based on substantive due process. And then throughout the 30s, 40s, and 50s, the court over and over again said that we are not going to judge the fairness of laws. That if there's some provision in the Bill of Rights, we'll enforce it. But if it's some sort of unenumerated right, courts, we're not going to do it. And then we get to Griswold, was it 1968 or 67, whatever it was. And Griswold, despite its best efforts, changes direction. And although they profess fidelity to Justice Holmes's dissent in Lochner, by the way, this is why I think people whitewash Buck v. Bell. They have such a veneration for Holmes because of Lochner. They look past Buck v. Bell, which I think is perhaps not deserved. But in Griswold, they said, listen, we're not doing Lochner. Why? Well, you have these penumbras from the emanations of the Bill of Rights. So we're not actually making this up. This actually comes from the penumbras and the emanation of the penumbra. Right? This is a clear textual case, or something like that. And then you have this concurring opinion by Justice Goldberg, who's saying, well, wait a minute, we have this 9th Amendment, which says just because rights aren't written down doesn't mean they don't exist. I'm not saying the 9th Amendment protects contraceptives, but, it's consistent with how the framers drafted the Bill of Rights. And then you have Justice Harlan, who writes, well, the 14th Amendment has this liberty provision, and it protects certain liberty interests. And then it's up to judges to decide what these liberty interests are. These rights that are implicit in the concept of ordered liberty, these really important rights, well, then courts have a role to protect them through this doctrine of substantive due process. Okay? So that's where we left off class last time. And I actually just make a mental note. The opinion in Griswold made emphatically clear that this case concerns the rights of marital privacy, right? You have the right of a husband and wife in the bedroom. This is a place the state should not intrude. And the essence of this right was that they had this privacy between the two of them. The court acknowledged, of course, the state can criminalize fornication. For those of you who don't know what that is, fornication refers to having sex out of marriage, right? Adultery, if you will. The court can criminalize fornication. They can criminalize sodomy. They can criminalize homosexuality. But what matters is the loving bond between husband and wife, and they can choose how to rear their children. That was the last paragraph of Justice Douglas's majority opinion. That is what, that's what the court was trying to convey. I don't say this lightly, but I'll say it. That was not genuine. That was not sincere. They didn't mean that. Everyone in 1968 knew where we were headed, right? There was a very deliberate legal strategy. First you do contraceptives, then you do abortion, right? This was a pit stop, if you will. You first have to get past this entire Lochner bugaboo, then you can move on to abortion, okay? So if you think of Griswold as just like a stop on a train, it's much better. It was never meant to be a decision unto itself. The fact of the matter is these laws concerning contraceptives were never enforced. Why? Who the hell is going to go into a bedroom and see people using condoms or a diaphragm, whatever it happens to be? These laws weren't enforced. The laws that were enforced affected something that wasn't in a bedroom. That's a surgical procedure that requires doctors and nurses and facilities, right? And things, right? If a doctor can lose his medical license for performing an abortion, okay, that can be enforced, right? So this was all gearing up to a legal challenge to states with various abortion laws in place, okay? But before they can get to abortion, they need to have another pit stop on this train, another stopover. There was that pesky holding in Griswold saying that, this right of privacy applies only to husband and wife. What about an unmarried woman who wants to seek an abortion? What's she going to do? She's not married. So the first case we have today, Eisenstadt, is a pit stop. The purpose of Eisenstadt was to basically nullify the holding of Griswold and to say, oh yeah, that entire thing we said that you can treat married people, unmarried people differently. Yeah, we didn't mean that. We didn't mean that. Just kidding. Yeah, you have to treat married, unmarried people alike. And oh, by the way, now any right to abortion would apply to married and unmarried couples alike. So the best way to see the progression from Griswold to Eisenstadt to Roe is a very deliberate legal strategy, in the same sense that in the civil rights movement, the NAACP went after, first law schools, then colleges, and then elementary schools, right? There was a progression. They were building. Here, there's a very similar legal strategy. And I want you to understand this because you will be lawyers one day, hopefully. All of you will be. And if you ever do any sort of litigation, you have to sequence it. And this was sequenced in this fashion quite deliberately to get us to the stage where Roe v. Wade would be decided. So any questions on that background? No? All right. Where did I finish last time? You're up? Okay. You want to tell me the facts, please, in Eisenstadt?
Yeah. So this one case is off.
All the single lady? Right. Never mind. Sorry, you
So
put your hands up. Right. Go ahead.
Guy was passing out.
I can't do the dance. I can't.
Articles, and he was arrested for it.
Oh no! Walk through. What was the manner? What was the forum in which Mr. Baird over here? I'll go over Mr. Baird in a minute. What was the form in which Mr. Baird handed out these articles?
It was kind of like an educational lecture.
Okay, good.
On contraceptives.
Okay, very good. So Bill Baird, and I'll give you some background on him. He's often called the father of the abortion rights movement. And he said he came to this mission in 1963. He said he was at a Harlem hospital and he saw a woman with a coat hanger protruding out of her uterus screaming in pain. And he said, she died in my arms. He told the story thousands of times, but this was his moment. So after that, he bought this dilapidated truck, which he called the plan van. And he basically started driving around New York City to the poorest neighborhoods, handing out birth control. He wasn't a doctor. He had no medical license whatsoever, but he handed out this information, these products. He was arrested a few times, but again, never prosecuted because, again, these laws weren't really enforced. People didn't really care about this. But the case we have here arose when in 1967 he gave a lecture at Boston University to a packed house. I think 2,000 people were in the crowd. And he displayed contraceptives during the lecture. And after the lecture, he gave to a young woman a condom and contraceptive foam. Okay, he did this to get arrested. This was very similar to the Griswold case, where they deliberately had the police come in and arrest them. Why? They wanted to try and get these laws to be challenged. Interestingly, not everyone agreed with his approach. At the time, Planned Parenthood called him an embarrassment, and so there was nothing to be gained by this case. But he went to court. He was sentenced to 3 months in jail. He served 36 days, and then he was released because his appeal was pending. All right, so first of all, let me show you some pictures. So this is Mr. Baird as he was younger. Here he is much later in life, and even later in life. Little contraceptives there. And even later in life. I think these are in chronological order. So what I want to show you actually an ad. So at issue here was something called EMCO vaginal foam. You have a sex ed class, I suppose. It says EMCO used by more women than any other non-prescription birth control product. And this is basically a spermicide. You put this in there and it's supposed to kill the sperm, right? Lesson learned. So what's interesting about this advertisement? Let's see if anyone notices it. What's interesting about this advertisement? There's a very, if you like to put a ring on it, right? Yeah. Oh, I'm on Beyonce mode today, right? There's a, someone put a ring on it. Right. So the key point here is she's married. This is a direct consequence of Griswold, the idea that this contraceptive right applies to married couples. So of course, if you're advertising this product, it's going to be promoted as a thing for married couples. I have another commercial here. The ad shows a mother and a father. And if you notice, the father is significantly older than the mother. I think that's quite deliberate. And the headline says, 3 reasons for spacing your children. It says, in small letters, when the family is spaced with the help of EMCO foam, mother has time to regain her vim and vigor, baby gets the abundant love he can thrive on, and dad gets a break. Expenses are stretched out to where he can handle them with a smile. So again, this was marketed as a product for married, I'll get to you in a second. This was marketed as a product for married couples. And you can look at these commercials later. I have a bunch of them. Here's another one. Why should our birth control method control us? And then it's just like, this back and forth between, again, a wife and a somewhat older husband discussing how to space out their kids. Yeah. Yeah, I'll go back to it. Oh my God, I never noticed that. I always thought that was the dad. You're right. I've been teaching this for you're the first to ever point that out.
Also, he's holding a clipboard.
Well, I didn't know. A clipboard, you know what?
I was like, all right, dad's like,
You know what? I've used this graphic for like 3 years. The first one to point that out. You know what? You're right. I take it back. You're right. That is a stethoscope. I didn't even notice that. The clipboard, I couldn't really tell what that was, but yeah, it's a clipboard. Okay. So why would they put the doctor there and not the dad? No, because no, and the reason why I thought it was the dad, it says because the expenses stretch out and the dad can smile. There's a picture of a guy smiling this. I almost like assumed the dad was smiling, but maybe the dad is the doctor. Well, in any event, the ad conveys marriage as part of the theme, which is what I was trying to get at. But Zachary, you're right. I will modify my lesson for next semester when I do this case again. Okay? Was that? What?
You said that someone was right. I was like, wow, I read that in my diary.
If someone's right, they're right. I don't admit. I don't. If I'm wrong, I'm wrong. That happens. I don't know everything. I really don't. Okay. So everyone okay with that? So this is what this MCO foam was. So the posture of the case is kind of weird. So he initially appealed his case up, and the state court system upheld it. You may or may not know this, but generally speaking, if you have a conviction in a state court, you can then challenge it in federal court in what's called habeas corpus proceedings. You can basically try and take a second stab at your conviction. So he basically then challenges it in a federal court. Okay, so it actually goes to federal court, and the First Circuit Court of Appeals in Boston actually rules in his favor, and they vacate his conviction. And then it goes to the Supreme Court. Okay, so all right. So Elizabeth, tell me, describe for me the law in effect in Massachusetts at that time, right? Who was and was not allowed to access birth control at this time?
So married couples were allowed to access birth control.
Good.
For contraceptive reasons, but then also singles were allowed to for preventing disease.
Okay. Could single people access birth control simply for prevention of pregnancy? For prevention of pregnancy. Okay. So now I have another question for you. Maybe Zachary can enlighten me again. What kind of contraceptive blocks diseases but not pregnancy? I know the other way around. Like the pill will prevent pregnancy but not disease. But what kind of, even the word contraceptive, contra against inception, right? What kind of contraceptive stops disease but not pregnancy? I ask this question every semester. I've never gotten it. Maybe you guys know. What Zachary?
I was gonna say, do you mean like in modern terms, or?
Well, I mean, in the 1960s or 70s.
I was about to say, well, 1960s or 70s, nothing.
What kind of product would prevent disease but not impregnation? I don't know what that is. Oh, that's like an HPV type thing? Yeah.
I feel like it's not a contraceptive.
Yeah, I mean, the entire point of the word contra against inception. I mean, the entire thing is birth control. So I don't know what this third category is, right? I've Googled this. I've tried researching. I don't know what drug would fit into this third category. In other words, what drugs could single people actually avail themselves of? I don't know. I go home and Google it. I don't know. But every semester I ask this question. I've never gotten an answer, so I don't know.
They have, I mean, you have like they have certain pills that you can take that lower your chance of contracting like HIV.
I don't think that exists in 1967.
That's why I said
Yeah.
it exists in 1967. That's why I asked.
Yeah, and again, that's not even preventing it. Just I don't know. I mean, the closest I ever got was a lambskin condom, which perhaps could prevent disease but won't prevent insemination. But if it rips, it rips. So I don't know. Yeah, I don't know. So in terms of the law's rationality, I think that would have been a much stronger argument. But whatever. We'll let that one. We'll let that one slide. No pun intended. So Zachary, you're up next. So Zachary, what were the state's interests in administering this law? Like what interest did the states put forward to defend this law?
I mean, I think they try to argue things like promoting health.
Okay, so one of them, you're right. One of them was promoting health, right? In what respect does this law, as it was written, promote health?
Like the risk posed by, I guess, like preventing the risk posed by contraception on an unmarried person probably have like a supporting thing. But I know another one was like the immoral, like they were saying.
Okay. We'll get to morality in a second, right? I'll promise I'll get there in a second. Okay. Beyond morality, I'll come back to Helen. What's another purpose that the state advanced? I want to get to morality second because it's a secondary issue. What was the primary reason why the state wanted to impose this sort of law where married couples could get this contraceptives and then unmarried people could not?
They said to discourage premarital.
Discourage premarital sex. Okay. How, in theory, at least, would this law discourage premarital sex?
Like,
Yeah. Well, what would be the argument? How could this law discourage premarital sex?
okay, well, they could say that by preventing single people or single they would have, there would be less of a chance that they would go out and use.
Ah, so thinking is this, right? If you're a woman considering having premarital sex and you know you have the risk of being pregnant, you may think twice about engaging in sex. Is that basically the argument? Okay. So the state basically argues that if people can't access birth control, they're less likely to have sex, premarital. If they're in the marital bond, they can. Now, before we get too far, Clayton, why do you think the law allowed married couples to have contraceptives? It's implicit in the case. They don't say it outright, but it's understood in the case. Why do you think the state allowed married couples to have contraceptives? Because of Griswold. The statute was amended a couple years earlier to comply with the Supreme Court. So originally, Massachusetts treated everyone equally. No one got it. Then they had to change it because of Griswold, and then the court struck it down because they treat married women and unmarried women differently. It's a scam, right? It's basically a bait and switch. You tell states, oh, you have to allow married people access to the contraceptives, and then you say, because you only allowed married people to have contraceptives, your statute's unconstitutional. Everyone see what's going on here. It's a bait and switch. It's remarkable. This is Brennan at his finest. It really is. This and Craig v. Bourne, these are his finest opinions in terms of what Brennan does. Now, a case in, how does Justice Brennan respond to the idea that whether or not this would actually discourage premarital sex?
He says that it's just a facade. It's not really, the real.
Why is this not really aimed at deterring premarital sex, according to Justice Brennan?
Because it discriminates against unmarried people.
Well, no. Why is this not really targeted at halting premarital sex? And think in terms of scrutiny here. I'll give you a hint. It's a doctor here, right? Yeah, it's a doctor, you're right. Looking at it, yeah. You're right. I've been looking at this for 3 years. I never saw it. It's like, the 3D eye puzzles. I never saw those. I can never get those to work. The 3D things like the magic eye, I can never get those to work, ever. Sorry, Kason. Why? Well, I'll give you an extra time to read. Why does Justice Brennan think the true purpose of this law was not actually for deterring premarital sex? Want to take a stab, Emma?
Is it punished the person that's distributing contraceptives more than the couple?
Okay, good. So I mentioned this before. Fornication, right? That is sex outside of the marital bond, was illegal. And Justice Brennan says, look, the punishment for fornication was what, like a fine or something stupid? 3 months in jail and a $30 fine. What are you laughing at? 3 days, 3 months, and $30, right? So the fine is a misdemeanor. It was a misdemeanor. So the fine for premarital sex was 3 months in jail at most, and $30 fine. The fine in this case for distributing contraceptives or using them was indeed 5 years in prison. So Brennan says, look, this is not right. If they're really concerned about punishing premarital sex, how is it that this punishment is like 20 times as great? Deterrence is not the purpose of the law, he says. Everyone see this? If this sort of modality rings a bell, it should. It should remind you of Craig v. Bourne. Remember with the Oklahoma beer case, Brennan said, the reason for this law is not actually highway safety. Remember that? Do you really have another reason in mind? This is the same sort of strict scrutiny-ish approach that Brennan applied in Craig v. Bourne is applying here. So this modality of thinking ought to sound familiar. Okay. Anna, let's move on to the second point Zachary made a moment ago. I want to take this out of order. Does Justice Brennan think this is actually about serving public health? Why is this not about serving public health?
Well, he talks about the chapter
Uh-huh.
that's all about
What chapter does it appear in?
crimes against chastity.
Chastity, right? Well, I mean, we're talking about a Puritan state. Massachusetts is it's the home of the Pilgrims, right? This is the Puritan state. Does Brennan really think this is about, women's health? No. So again, this is a sort of strict scrutiny where Brennan's looking behind the curtain, right? He's saying, look, this thing is not about health. What is it about, Anna? What's morality, right? Morality. So, okay. So now this, in the third part, this is trademark Brennan. This is, like, if I could summarize Brennan in one paragraph, it's this paragraph. So he's building up to this argument saying, this law is about morality, and morality is not a valid basis to pass laws. He doesn't say that, though. Instead, he quotes the lower court saying it and says, we don't need to address this. This is Brennan in a nutshell. So the third party says, look, it's not deterring premarital sex. It's not about health, right? So I'm going to quote the lower court. And the lower court said, such a view of morality is not sensible legislation. This is basically judging the wisdom of the law, saying moral-based laws are not a valid basis. But then he says, we don't need to decide that, right? We don't need to decide that question. We just hold it's not in the competency of the state. That's it. The Brennan move, and I just hope you appreciate his craft, is when he does the thing where he basically lays out the entire argument and says, but we don't need to decide that. But he's giving the argument to the lower courts. He's giving the argument to other people to make in the future. He's planting these seeds for how future courts will approach this. And he does this in the next paragraph. And again, this is probably the most Brennan opinion you'll ever read. It's masterful, right? He writes, it's unconstitutional to treat married couples and unmarried couples differently. You can't do this. Now, again, I told you the bait and switch. They just said 7 years earlier, yes, you can give the special right to married couples. Now he's saying that's unconstitutional. Wait a minute, Delaney. How do we approach equal protection? Right? What's the first question we ask ourselves when we do equal protection question? What do we look for? What's the general approach of how we, the entire thing, Craig v. Boren, right? What do we think about when we do equal protection questions?
My interpretation of it.
Not what Brennan wrote, generally.
So you're saying in general?
In general, how do we approach equal protection? What's the first question we ask ourselves? We'll review.
Oh, equal protection is categories.
Yeah, what's the class of people here, right? So what's the classification in this case?
Your status as a married or unmarried.
Okay, now, has the court ever afforded strict scrutiny when you treat married or unmarried couples alike?
No.
Have they ever afforded rational basis whenever you treat married and unmarried couples alike?
No.
What rational basis?
I guess when in what was one before this?
Griswold?
Griswold, they did because they said that because there was a rational basis between giving married couples contraceptives and unmarried that they were promoting public health.
Well, no, you're answering too far. What standard review do we apply to a classification basis of gender?
Of gender,
I'm sorry, marital status.
that there's the rational basis.
Rational basis. And under rational basis, what do the courts usually do?
Oh, they always win.
The government wins. Does Brennan mention scrutiny here at all, Delaney? Or John, you're nodding your head. Does it make any discussion of here's a scrutiny or classification or so he just says equal protection, whatever?
Yeah.
Okay. Why does he do this?
Obviously to set the ground for.
Okay, yeah. Basically, this entire big fight which they had in Craig v. Boren, which was right around the same time, about whether gender gets intermediate scrutiny, he just throws that aside and says, you know what? This violates equal protection. Even though their opinion 7 years earlier said you can treat married couples differently. This is the most Brennan thing in the world. It's a beauty. I mean, I want you guys to admire the craft. Like, whether you agree with the logic or not, I don't care. But the craft here is beautiful. The next sentence, though, this is a beauty. Let me read it to you. And just I want you to put a star next to your notes. It says, if the right of privacy means anything, and by the way, Brennan always put the key points like in the last paragraph. He always buried stuff. Remember in Craig v. Boren, he put the test for intermediate scrutiny in the last paragraph. Did it again. He was a master. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as a decision whether to, here comes the key one, right? Bear or beget a child. Bear or beget a child. Samuel, what's going on here? What's he saying? What's he getting at there?
He's trying to separate an act of sex
Yeah,
from an act of bear begetting a child.
giving birth, right? So I always get them confused. I never remember which is which, but beget is sex, right? Bear means carry to term. This case, the entire nature of the case is whether there is fertilization, right? A contraceptive prevents fertilization. And he's saying bear or beget. So he's saying, look, this right of privacy is not just about getting pregnant. It's about the choice to bear it and carry it to term. You can be damn sure he was writing this for Roe v. Wade. How do I know this? Because Roe had already been argued at this point. Roe was argued twice, and they decided this one in the middle. This was literally a pit stop. I use that phrase, but it works. He was writing this decision for Justice Blackmun for Justice Blackmun to finish the opinion in Roe. And you want to know what? They cited this. Everyone knows this? They quoted this sentence. And you want to know what else? In Casey, they quoted this sentence. This sentence, which Brennan pulled out of thin air, becomes Supreme Court law, right? That's why the entire discussion of precedent in Casey is so deep, because Brennan just made this up, right? It came from nowhere. It buried in the last sentence of the opinion. But the bear beget part, becomes the crux. And just think about this modality of thinking. If the right of privacy means anything, it is the right of individual, blah, blah, blah. What does that mean if it means anything, right? There's no reasoning. There's nothing. It's just there. It's like here, 5 votes, right? Done. And actually, I think I had more than, I think I had 7 votes or 8 votes. But no, there were 7 justices. So I think we had 6 votes. But that was it. All right. So I admire the craft of Brennan. He didn't always write majority opinions, but when he did, they were like this, or Craig v. Boren. I think, didn't he also write did he write Asahi? One of your Cipro cases also that confuses students for generations. Was it Asahi or Worldwide Volkswagen? I can't remember which one it was, but one of those he wrote, and it was awful because it confuses students forever. Okay. By the way, now you know why stream of commerce comes from, the Commerce Clause. Oh. See? Okay, it all connects. All right, any questions of the majority? Yeah, Brennan. Yeah, Scotty.
I was gonna say, I feel it's a recurring theme with Brennan. Just, not only just stick these little bits at the end of his opinion, but have them be just generic enough that you could reuse them and recycle them.
Yep.
And for not only that he can reuse them in a following case, but other justices can as well. And he does this constantly.
Yeah, he was a master at it. I mean, I agree with him or not, he was a master at this. They're called time bombs. There's actually a name for them. We would put these language in an opinion that would then be cited at some other point in the future, right? It seems innocuous here, but it's put in there for the sole purpose of being then relied on later in some other decision, long after he's gone. Right? I'll give you a second, Delaney. There's actually a key phrase in the Bergeville decision, the same-sex marriage decision, from a case called USDA versus Moreno. The case was, funny fact, during the 1970s, Congress tried passing laws preventing hippies from collecting food stamps. So basically, you had all these hippies living on communes, and Congress didn't like the hippies. So Brennan had this one phrase saying that there was basically a bare desire to harm these people, a bare desire to harm. That is basically the crux of Justice Kennedy's decision in the gay marriage case. There's a bare desire to harm. So this innocuous language that Brennan threw in there, like Scotty said, about hippies, was then expanded to refer to laws limiting marriage to a man and a woman. Just pay attention to this stuff. It's Brennan, he's still with us. It's like Mustafa on the Lion King. He's still with us. We can't, it's always in there. Yeah, Delaney.
For clarification purposes, you're saying that it's
What about Mustafa, right? Or is it Mufasa? No, Mufasa. Oh, no, Mufasa from the Lion King. I'm sorry. I'm wrong again twice in one day. It happens. So what was your question?
Okay, for clarification purposes, you're saying that Brennan says that it's unconstitutional to separate unmarried from married couples. Why? Isn't that I don't understand.
He ignores old doctrine. It doesn't matter. That's what I'm trying to convey to you. It doesn't matter. I mean, much like the next case, you know, remember that show Whose Lines in Anyway? You know that show? Where points don't matter? Yeah, that's like today's class. No, it wasn't Drew Carey. It was Drew Carey.
Oh, Drew Carey.
So it was wrong now. So. It's okay. That's okay. It's okay. John's giving you a pat in the back. Right. So it doesn't matter. He just blows past doctrine because it doesn't matter. This was, I mean, it doesn't matter. The doctrine is irrelevant. It really, whatever. Okay. So another question of the majority. And I don't say that to criticize the actual substance of the law. I'm saying the reasoning is just, it's not there. Right? All right. So Justice Douglas, who again wrote the majority opinion in Griswold, tries to see this as a First Amendment case, as giving information. The difficulty with this, of course, is he actually gave out a controlled substance. It was it was an article that you needed a medical license to distribute. You know, there's actually cases now. There was actually a blogger. You know this paleo diet thing? There was actually a blogger who would give out advice on how to run a paleo diet. And the North Carolina Department of Health tried to shut down his blog saying he meant medical advice. Like, no, I'm telling people to give a diet. I mean, so this sort of issue of when you give medical advice versus free speech still comes up. Justice White had an opinion that, you know, it's really strange. He said the record doesn't say whether the woman who got this drug was married or not. So that way, you know, we can't affirm the conviction. The difficulty here is that Mr. Baird never challenged the sufficiency of the evidence. I mean, don't you think if he was going to be convicted for a crime who said in evidence she was married, do you think his lawyer would have raised that? Now, here's a pro tip. If you waive an argument in the trial court, in other words, if you don't make your objection at the right time, it's waived, right? If you don't object at the moment, as a lawyer, that argument's gone. You can't raise it on appeal for the first time. So I mean, this current opinion, you know, makes no sense because it's not a thing a court can do. I think Justice White, who dissented in Roe the following year, just wasn't comfortable with this. So we found, all right, here's a way I can affirm the dismissal without going into this constitutional stuff. The only dissent was actually Chief Justice Berger. And Chief Justice Berger makes the point saying, look, guys, right, this is Lochner we're doing here, right? This is Lochner. You're basically judging the substantive wisdom of a law. We said we weren't going to do this anymore, right? We said we weren't going to do this anymore. Berger says there's no reason why the court should be involved here. Now, query, if you will, how did Berger dissent in this case but join the majority opinion in Roe? I don't know. I think it was one of those cases where he didn't want to be in dissent in a case like Roe. He thought it'd be like a big success. In fact, I'm moving on to Roe, but Roe was actually, let me get the dates here. Roe was actually argued twice, I think I said before. And Chief Justice Berger, who was the highest seniority, assigned the opinion to Blackmun. M-U-N, there's no relation. That's it all the time. Once a court, the Seventh Circuit, cited me, one of the articles I wrote. I was like, yay, and they spelled my name like the justice, and I had to get changed, but I got changed. It'll come from Westlaw, don't worry, it's good. So Berger assigned the opinion to Blackmun, and there was this massive effort to have the case re-argued and develop it. So this was going on for a while. But I still can't quite figure out how Berger could write this dissent and then a year later join the Roe majority. I don't know. I don't have the ideas. I welcome your suggestions. But the reasoning in Roe seems pretty consistent with the reasoning in Eisenstadt.
Don't judges ever change their opinion? So you can dissent to the opinion from this particular case, but because the majority changes to what the majority.
What a very good question. So there's something called a perpetual dissent, and Scott, I'll get to in a minute. Something called a perpetual dissent. So, for example, Justices Brennan and Marshall decided that death penalty was unconstitutional in all regards. So for about 20 years, in every single death penalty case, they would dissent. Every single one. Even after the Supreme Court said this is constitutional, they would keep dissenting. Some judges do the perpetual dissent, some don't. Maybe perhaps here Justice Berger said, well, you know, I had my kicks in Eisenstadt, but I'll go along with the crowd. But that's the minority. Usually justices that dissent keep on trucking. Scotty?
Honestly, maybe you know, as Sandra Day O'Connor got up there in her years, I think she slid a little bit to the left, and I think that's because of how she wanted to be remembered on the bench. You make the same argument that as Berger age.
Well, there's only about a year that elapsed here. So this was like 1972 to 1973. There wasn't that much time. But I mean, your point, though, I think your second point is actually stronger. That he thought that in 30 years, this is a pivot point. The majority opinion in Roe, if you had asked the justices, they thought we are going to be resolving this massive social issue, and in 30 years, everyone's going to look back at Roe and say, "Wow, what an awesome decision!" Right? They thought they were going to resolve the issue of abortion with this trimester framework. So I think Scotty's point is actually the second part, maybe stronger. Perhaps Berger thought, "Man, this is going to be a good decision. I want in on this, right? I want in on this." Maybe, I don't know. I mean, I always ask this question because I don't know the answer, but it's worth thinking about. Okay. Any other questions on Eisenstadt? Again, the case is just a pit stop to Roe. That's how you have to think about it. No? All right. So the next case, I think, as the book notes well, it needs no introduction. And the case, of course, is Roe v. Wade. Roe was a pseudonym. Her actual name was Norma McCorvey. That's her over there with Gloria Allred, who, this was in 1989. She looks exactly the same, which is kind of crazy. But that's Norma McCorvey. Here she is in 1985. Here she is at an earlier date. So perhaps much like Buck v. Bell, the facts of this case are not even remotely close to how they're portrayed in the written opinion. So I'll give this caveat first. Roe became this, McCorvey became this icon of abortion rights and gender equality and everything else. But in the late early 1990s, she found Christ and became a staunch defender or a staunch opponent of abortion. And in fact, she became one of the strongest outspoken critics of the decision that bore her name. So, and again, I say this with a caveat, but years later, in 1998, so 25 years after the entire thing happened, she testified before Congress, and she provided a different version of the facts. So the facts in the case say that she was a young, unwed mother who wanted to get an abortion but couldn't afford it. I'm going to read from some of her testimony. But basically, at the time, she was living in Texas and she wanted to get an abortion. And she was asking around. And these two lawyers found out. And these two lawyers wanted to challenge the Texas abortion law. And they were looking for a plaintiff. And they found McCorvey. Now, this part, again, she basically said, I didn't want anything to do with the case. I wanted to get an abortion. Right? She didn't want to be a plaintiff. She wanted to terminate the pregnancy. But these women apparently pressured her. And they told her in the complaint to say that she was raped because they thought the rape would make the case more, winnable. She wasn't raped. They said that was a total fabrication. But in the meantime, McCorvey actually gave birth. The only reason why her case remains alive is that she didn't actually get the abortion. So she gave birth, and I think the baby was adopted. One small note, though, if anyone wants to take a stab at this, you can. Generally speaking, you can only challenge something in court when there's an injury, when you're standing. When she filed the case, she was still pregnant, but by the time the case wound its way up, she had already given birth. There was no more, there was no more abortion for her to be had. Does anyone want to take a guess about why she's still outstanding? It was actually it's a doctrine that comes up in this case. You want to take a guess, Scotty?
Technically, no, don't you only really have 9 months of standing?
Well, that's the problem, right? This is the thing that goes away after 9 months or so, one way or the other. So the court actually created a doctrine, and I'll give you what it's called: capable of repetition, yet evading review. Capable of repetition, yet evading review. Okay? What does that mean? Effectively, this is something very unique. It's a constitutional injury that will only last at most for 9 months. And it's impossible for a person to get a full judicial review in this window. Because indeed, most women don't even know they're pregnant right away, so it's probably more like 7 or 8 months, however you want to count it. So the court basically said, well, even though she had already given birth, we'll just look past that. And I think they cut that out. Okay. So in any event, eventually the law evolved, and she claimed in her affidavit that not only was she raped, that she was gang raped. And each time she told the story got a little bit different. She later said that these lawyers used her as their dupe, and she did not want to be part of this. So they bring this complaint in federal court in Dallas, and that she's seeking to get this abortion. Now, if you notice, they brought a suit challenging that it was unconstitutional under the ready, 1st, 4th, 5th, 19th, and the 14th Amendment. This is what we call a kitchen sink complaint. You throw the entire Constitution, you throw the entire Bill of Rights at them. Does anyone want to figure out what the 4th Amendment argument would be? Did you do the 4th Amendment yet? The 4th Amendment prohibits unreasonable searches and seizures. And they actually claimed that they were seizing her body by not letting her have an abortion. In fact, there was a note, which I hope you read, saying that there's a professor who said that abortion laws violate the 13th Amendment because they basically force women to become a slave to carry the child to term. Okay? And what's interesting, and I think someone over there asked me about this yesterday, the district court actually ruled against them on the 9th Amendment grounds. They actually said that the 9th Amendment now applies to the states to the 14th Amendment, right? So Goldberg didn't even need to say the 9th Amendment applies. He said to plant the seed. And then some district court judge in Dallas said, oh yeah, the 9th Amendment protects the right to abortion. Even though it only applies to the federal government, we'll extend it through the 14th Amendment. Okay? This cough will not leave me. It's been here for 3 weeks. It's driving me nuts. Okay. So the introduction to Justice Blackmun's opinion, it's interesting. So he acknowledges awareness of the sensitive issues, and he tries to say that your philosophy and how you view these images may decide how you approach abortion. And he has this one sentence, which I always like to stress, lest you think eugenics is dead. He says, in addition, population growth, pollution, poverty, and racial overtones tend to complicate and not simplify the problem. What does population growth and pollution have to do with abortion? Anyone want to take a guess? I think this is 1970, so what's going on then?
More people there are, the more resources they use. This was the beginning of the concern of environmental issues. So if you have less people, you need less resources.
These were the Malthusians. What the Malthusians are. Who are the Malthusians? What did Malthus say?
Limited amount of resources.
Right. So the Malthusians, they've always been around. They've always been proven wrong. Is that the human beings will eventually reach a point where we run out of resources. They've been proven wrong at every juncture. But in the 1970s, one of the most popular books was A Population Bomb, which basically argued that by the year 2000 or so, the world will be unable to sustain the population growth. We'll be out of resources, we'll be out of food, and we need to start basically controlling the population so we don't run out of food. So unless you think Buck v. Bell and eugenics was gone, don't. His sentence there, and he actually favorably quotes Buck v. Bell later in the opinion. They cut out every book, which drives me nuts. I hate that they do that. But Blackmun was buying into the to this eugenics stuff. Okay. But then he says, but we're not deciding this on the basis of emotions, right? He quotes from Holmes, The Dissent, and Lochner, and he says, you know what? We are not going to be in the business of, deciding emotional things. The irony, of course, and here's the greatest irony, they're citing Holmes, the justice who held that the state can sterilize women, for the proposition that states cannot prohibit abortions. The irony there, I'm sure, was lost on Justice Blackmun, but there's a very strong irony there. That Holmes would vote that people can be mandated to have abortions. Anyway, we move on to standing. Okay. So the court addresses a couple rationales for abortion laws. Antonique, what are give me one of the rationales of how the state justifies, how Texas justifies this law.
Well, they said that they were trying to protect the fetus.
Okay, good. So one of the concerns of the state is to protect what the court refers to as the potentiality of life. The court dodges the philosophical issue of whether indeed the fetus is a life by referring to it as the potentiality of life. Maybe yes, maybe no, we don't know. We won't decide. So that's one of the rationales. Zach, what's another one of the rationales that the state identifies to justify their abortion laws?
It goes back to discouraging premarital sex.
Yeah. Discouraging illegal sexual conduct, exactly. The thinking is, well, if a woman knows that she can have an abortion on the back end, then she'll be more likely to engage in premarital sex. Okay, that's basically the thinking. Sheridan, what's another rationale the state puts forward to defend the law?
Also, they were taking into interest the mother's life.
Yes, the health of the mother, right? Indeed, most medical procedures are required to be performed by a licensed doctor. And they say, we want to make sure that women have access to healthy procedures and they're not being put into undue danger. Okay? So I think those are probably the three major defenses of an abortion law. The fact that you're trying to discourage illicit sexual conduct, you have concern for the safety of the woman, and also you have concern for the life of, or the potentiality of life, as the court frames it. Texas doesn't actually rely on the first one, but the court knows that could be a potential defense. Okay? So the crux of the court's analysis, and they summarize it in one sentence. The court says, the state has a definite interest in protecting a woman's health and safety when abortion is at a later stage. Okay? The state has an interest in protecting the health of the mother when the abortion happens at a later stage. Okay? The consequence of that is at earlier stages, the state's interest in the health of the mother decreases. At the same time, though, the state's interest in the potentiality of life is greater towards the end of the pregnancy. So you have these two things kind of working together, right? As the months tick up, 1, 2, 3, 4, 5, whatever, the state's interest in the mother's health and the state's interest in the potentiality of life increase. And in such cases, the state has a greater authority to impose various restrictions on accessing abortion. However, okay, just a second. Earlier in the pregnancy, where the potentiality for life isn't so great, and indeed the risks of health of the mother aren't so great, the state's interest then is actually quite low, the court says. And the state has less authority then to impose these sorts of restrictions. Zachary?
I understand that the interest of the state increases with the potentiality of life as later stages go advance, but the interest in the mother's health should be equal in both situations. situations. I know the risk is higher. Later
Well, that's
stages,
exactly why.
but it still should be the same.
So what's interesting about Justice Blackmun, he was from Minneapolis. He was actually the general counsel at the Mayo Clinic in Minneapolis before he was a judge. And if I get this right, the summer before he wrote this decision, he basically went to the Mayo Clinic and was researching everything about abortion. I mean, there was a section they cut out of your book, which you're grateful they did, but I read it when I was in law school, about the history of abortion in Persia and Rome and Greece and all this other stuff. But yeah, this long-winded section about every history of abortion. And he basically said, based on the science as existed then, as you said, the risk from the abortion increases by month. So he had both those on the same scale. Okay. In other words, the state's interest in health isn't so great where the risk is a low risk procedure. That's what he said. Okay. Now, how does he get there? Okay. There's a quote from Justice Henry Friendly. Henry Friendly was one of the great circuit judges to never serve in the Supreme Court. John Roberts clerked for him, very, very famous judge. And he said, and I'm paraphrasing, the decision in Roe isn't law, and it makes no attempt to pretend to be. Right? It doesn't pretend that it's any sort of legal decision. In fact, it has like a press release at the end to make sure we understand the holding. I'm sure you wish more decisions had this little closing paragraph telling exactly what the holding is. It makes your recitation that much simpler, right? But Ryan, how does the court attempt to ground this in some sort of legal principles? What is it doing here?
He says that there is a right to privacy founded in the 14th Amendment, and then cites specific past proceedings. And he says that that right is broad enough to include the right to the decision of whether to have.
Okay, good. So it's effectively a species of substantive due process. The argument is there's this liberty interest in the 14th Amendment. This liberty interest includes the right of privacy, and the privacy interest is broad enough to include a right to terminate a pregnancy. He cites a number of cases. He cites Loving versus Virginia, we studied. He cites Eisenstadt. He cites Pierce v. Society of Sisters. And he tries to say that courts are able to identify this liberty interest. Now, Justice Rehnquist, in his dissent, counters says, wait a minute. The test we use to decide if a right is fundamental is whether something is implicit in the concept of ordered liberty. Now, Rehnquist says, listen, every state in the Union has been banning this for over, since for over 100 years. How can it be that this right is so fundamental, that it's so deeply accepted, if every state has these laws in effect? The majority doesn't engage this, and they make no attempt to base this on history or tradition. It's effectively what the court sees as fundamental, what the court sees as an important right. And despite the admonitions in the first paragraph, he's saying, look, we think this is really important, right? 14th Amendment, 9th Amendment, doesn't really matter where we're getting it from. Okay. So the actual holding of the case itself isn't particularly complicated. It isn't. The court says that abortion is a fundamental right. And because it's a fundamental right, you apply strict scrutiny. The state does have a compelling interest in the health of the mother and in the potentiality of life. But that state interest increases as the months of the pregnancy go on. So earlier in the pregnancy, the state has a very low interest in protecting the health of the mother. And indeed, no interest in protecting the potentiality of life. Only later on in the pregnancy, we'll get to the trimesters in a minute, but only later on in the pregnancy does the state get an interest in protecting the potentiality of life. Okay. So he does make one argument, though, which is textually sound. So a lot of arguments are made that the 14th Amendment protects unborn children. The problem is, if you flip to your constitutions on page 49, or sorry, 48, I should know that by heart, it says all persons born or naturalized are citizens. So the word born is in there. I'm 100% positive that when they wrote that, they weren't thinking about abortion, but in any event, we follow the text. And the text says a person born is a citizen. So if you're unborn, you're not a citizen. So the 14th Amendment doesn't cover the unborn. But that doesn't mean the state doesn't have an interest in protecting them. The state has a police power separate and apart from the 14th Amendment. Okay. Okay. So then we get to what I call the press release. And perhaps it's not a very good way to describe it. But at the very end of the opinion, have you ever seen an opinion like this where it lays it out in bullet points? Have you ever seen that? It looks like a commercial outline that you guys read before class, right? So it kind of looks. I know. Some of you bring it to class. It's really obvious. I see you with them. I once had a professor who saw a student flipping that. He's like, okay, you can leave now. I won't do that. I'd rather you be here than sit in the hallway. So the press release. The reason why I call it that is it reads like a statute. Court decisions are generally written in such a way to provide general principles which we apply, the test. This reads like a statute. If you're in the first trimester, these rules. If you're in the second trimester, here are these rules. And then the third trimester, but here are these rules, right? So what is the test? I mean, the Constitution's silent on trimesters, I suppose, but the court fashions this framework. So during the first trimester, that's during the first 3 months that a woman is pregnant. So the state has an interest in protecting the mother's health. Okay. The state has this interest in protecting health, but they don't really have an interest in concerning about the life of the child, the potentiality of life. The only sorts of regulation that the state can impose during the first trimester concern the health of the mother. In other words, the state can't regulate the first trimester to try and promote human life. That's just not something that can be done. Okay. The second trimester, that is months 4 through 6. During the second trimester, the state, I'm sorry, oh, I screwed it up. I did the Casey one. I'm sorry, I said it wrong. I always get these confused. During the first trimester, it's basically left to the judgment of the doctor, right? The state really has, so long as a doctor is licensed, he can do whatever he wants during the first trimester. I'm sorry, I always confuse it with cases because Casey revised it. So during the first trimester, it's basically left to the choice between the doctor and the patient. And then you can have laws discussing like, medical standards and licensing and stuff, but there actually can't be any abortion laws during the first 3 months. And indeed, I'm wrong 3 times one day, Delaney. See, it happens. So if you actually, this was the front page of the New York Times the day after Roe was decided. And if you have to summarize the case in one sentence, High Court rules abortion is legal for the first 3 months. So it basically legalized all the abortions for the first 3 months. Can you imagine though Roe didn't even make the top billing because LBJ died that day? So the rest of the headline. Yeah, President Johnson died the same day. Okay. During the second trimester, and only in the second trimester, does the state now have an interest in regulating abortion to promote maternal health. So the state can now have additional rules governing whether the mother's health is provided for. Okay. The court then draws a line of viability at the third trimester, which is roughly the 6th month. And during the third trimester, the state may promote the potentiality of human life, regulate or even ban abortion, except where it's necessary for the health of the mother or the life or the health of the mother. So really the only time under Roe where the state can consider the potentiality of life is after the 6th month. At that point, they can ban abortion or do whatever they want. But the first 6 months, according to Roe, the state has no compelling interest in doing anything to promote human life. Everyone get the framework. Yeah, Scotty.
When I was reading this, I broke it down into not the bullet points, but the points they did here. To me, this reads more like a statute than it does a judicial opinion.
Yeah.
And
yeah.
not that I have feelings one way or the other, but it seems
No.
like legislation from the bench. Like
Well,
legislating from the bench.
so-
by setting these prognostic criteria.
So I think the lesson we learned from Casey, and we'll talk about this in a few minutes with Casey, but this reads like a statute, right? You can imagine a legislature passing a statute saying abortion from this month to this month has this regulation, this month has regulations. It doesn't read like a judicial opinion, and that's totally apart from the merits of whether it's right or wrong. The court here was attempting to resolve a massive dispute. Let me explain it this way. The court was trying to say, listen, we have 50 states. All these states have different abortion laws. We can't have this. Let's put down a clear standard that all 50 states will not have to comply with. Because indeed, once this decision dropped, every state in the union had to revisit their abortion laws. Right? This is a Texas case, but every state in the union had to revisit their abortion laws after this case. I think they're trying to resolve once and for all the issue of abortion. I'm going to fast forward briefly to Justice Scalia's dissent in Casey. You don't have to flip your pages, it's fine. And Justice Scalia's dissent in Casey compares Roe not to perhaps Plessy or Lochner, but to another case which you studied, which is Dred Scott. And Scalia makes this comparison where he says, courts should not be in the business of trying to resolve massive social disputes. And he says there was a decision before where the court tried to resolve a massive social dispute. It involved Voldemort, also known as Chief Justice Taney. And he says, look, Justice Taney wanted to write a decision that would end the Civil War or prevent the Civil War. He wanted to write a decision that would resolve the issue of slavery. As history tells us, it didn't work. And in fact, exacerbated, it made worse the struggle between North and South, and indeed ushered in the Civil War. What Scalia didn't note, but he was writing against his backdrop, is that the modern day evangelical movement was born out of Roe, no pun intended. The modern evangelical movement, the pro-life community, didn't really exist before Roe. This may shock you, but for a number of churches in the 1950s and 60s, abortion wasn't a big issue. In fact, if I can go back to the headline, it says, cardinal shock, reactions mix, right? People didn't really have the sort of strong reaction we have about Roe, but indeed, Roe galvanized the issue of abortion. And no less than Justice Ginsburg has said that Roe was a mistake. Not that they got it wrong, but that they moved too fast and too quickly. That by administering this statute in 1973, of actually writing, it looks like a statute, they tried to take this issue out of the popular sphere. And if you actually looked and studied how abortion laws were trending in the years leading to Roe, most states were actually liberalizing their laws. They were actually opening up abortion laws. A strong argument can be made, and I think it's pretty persuasive, that Roe retarded the movement towards liberalizing abortion laws, because now people were so angry at this issue that they actually started making it harder. And you can query if the court didn't do what it did then. Maybe it stretched it out a little bit here, a little bit there. If this issue would be quite as divisive as it is today. This is the point that Scalia makes, and he compares Roe to Dred Scott of how the court tried to resolve it. Keep this same issue in mind when you read Chief Justice Roberts' dissent in a Bergefell, the same-sex marriage decision, which we'll read next week or whatever. It's long. Make sure you give yourself time to read it. It's long. It's really long, but you have to read it. And Chief Justice Roberts makes the point that the Bergefell decision is a shame. In what respect? Leading up to the Supreme Court's decision in Bergefell, state after state had started to legalize same-sex marriage. I'm not talking about the ones by court order. Those are a different boat. People were voting and moving towards this. And what Chief Justice Roberts wrote is that the Bergefell decision cheated us out of the democratic process, right? The victory of knowing that you got what you wanted through the ballot box and not through the court. That victory was deprived by the Supreme Court's decision. So when you read the Chief's dissent in Obergefell, I want you to trace it back to Scalia in Casey, and then he traces it back to Tawney in Dred Scott, and think about how the democratic process is influenced by courts. And when courts make these wide-ranging decisions on issues of massive social importance, how does that affect the political process?
Just a quick question. If most of the 50 states have abortion laws similar to Texas, which pretty much only gave one exception.
That wasn't the case. No, a lot of states had actually started opening them up for Roe,
In what way?
making them easier to get. That it wasn't just for the life or health of the mother. States were actually legalizing them in various terms before Roe. Yeah, it's true.
No, that's why I'm asking. To what extent actually did it?
There was a good book by Linda Greenhouse and Reva Siegel. What's it called? Before Roe. It was published 2 or 3 years ago, and they actually chronicled all of the various abortion laws that existed leading up to the Roe decision. I don't have that at my fingertips, but it's by Reva Siegel and Linda Greenhouse. I think it was called Before Roe or something like that. But you can, I can look up later and tell you. I don't know off the top of my head. Scotty, hand up. Oh, I saw a hand in its vicinity. My peripheral vision perhaps isn't as good with these stupid glasses on. Oh, the book was called Before and After Roe. Yep, that was it. Okay, Sam, please go ahead.
Wasn't it actually like you talk about there were a lot of, it wasn't a big, great religious thing that happened at the time. Wasn't it a stated purpose of the Christian, the moral majority people?
They didn't exist yet.
Yeah, or like we're not sorry, moral majority.
The Catholic Church?
The evangelical church.
Because
a bunch of the evangelical preachers who had started getting politically active at the time, they actually said like this is a Catholic issue. Protestants don't care about abortion.
Yes.
And they said,
yes,
and
you're right.
In the late 70s,
You're right.
Said, well, we're not winning a lot of elections. I know. If we go, and this is like not a secret or anything, it's very stated.
Yeah.
If we decide that we're against abortion, we can get the Catholic vote. And that was all it was for. And so now,
you lost me at the last part. Okay.
You can find a lot of quotes by
You had me till the end.
preachers.
It wasn't to get the Catholic vote, but that was so the Catholics were against abortion eugenics from the time of Buckley Bell. They were always against it. This is, by the way, this is the book Before Roe v. Wade by Linda Greenhouse and Reva Siegel. If you're interested, for the low price of $1.52, you can buy that copy on Amazon. I guess that's what happens to books when they don't get read anymore. My books are that price. So, but you had me till the end, Samuel. So yes, it's indeed true that if you actually look at the statements of the various Protestant religions before Roe, and you read their founding charters and the principles, abortion wasn't mentioned, but they viewed abortion as a way to galvanize the issue and rebel against this issue and basically gain votes. So read this book if you want. If you don't, I don't care. But this answers Dan's question. I always give people books. I know they're not going to read it, but I try. Okay. So any questions in the Roe majority? Okay. So there's a concurring opinion by Justice Stewart, Potter Stewart. Justice Potter Stewart is most famous, and I may never mention him again, so I'll say it now. He had a case involving obscenity, and he famously wrote, "Obscenity, I know it when I see it." Now, people always say, pornography, I know when I see it. No, it's not pornography, it's obscenity. Obscenity is a certain type of pornography that's illegal. Okay, what's obscene today? It's a very, bizarre question because we're so messed up. I'm actually not joking. The test for obscenity reflects community decency. With the internet, I don't think we have it anymore. We are such a debauched culture. I can't even fathom what would be beyond community decency. I don't even know. But that goes without saying. So Stewart basically comes to grips with Lochner. He says, look, we said we rejected Lochner before. We didn't. We're basically embracing it, and I'm okay with that. I'm okay with that. I'm not gonna pretend it's Lochner. Fine. The lead dissent was by Justice Rehnquist, and Justice Rehnquist had been in the court at the time for a few months. He was a brand new junior justice. I don't know if you know this, but the Supreme Court during the conference when they vote, only the justices are allowed in the room. So the tradition is that the junior justice, the newest justice, is required to answer the door. I know this sounds stupid, but very often people bring in food, they bring in drinks, they have to knock on the door. And the second the door is knocked, the junior justice must run up and get the door. If the junior justice fails to do this, they sit there and they stare at him or her. It's like, okay, because they will not get up. They'll just sit there and wait. So Justice Kagan said the first, oh no, who was it? I don't know if it was Kagan or maybe it was Sotomayor, I can't remember, but the first time they forgot to stand up and like they got stared at, and they learned very quickly the junior justice gets the door. The junior justice is also responsible for the cafeteria committee. There's a cafeteria in the Supreme Court, and Justice Kagan's, I swear, her biggest innovation at the court is frozen yogurt. She got a froyo machine put in the basement. So now if you ever go to the Supreme Court and you get frozen yogurt, you thank Justice Kagan. The stuff you learn in this class, right? It's true. So Justice Rehnquist, who was, by that point was the junior justice, dissents, and he effectively repeats the sort of objections that Justice Berger had a year earlier concerning Eisenstadt. And he says, look, this is not in the Constitution. There's absolutely nothing in the Constitution about this. You guys are citing Holmes's dissent, but you're doing what Lochner did. There's not a difference here. You know, this is not any sort of law at all. And in fact, to Scotty's question, Justice Rehnquist calls it, quote, judicial legislation. He even says, look, you're writing a statute here, guys. Excuse me. Justice White, who's usually fairly reserved, Justice Whizzer White, he was actually a running back, I think, for the University of Michigan and played in the NFL for a few seasons. So you think he was a huge guy. He always won the basketball tournaments at the court. Yeah, actually, there's a basketball court on the roof of the Supreme Court, the top floor. It's called the highest court in the land. Although the ceiling is actually very low because it's a building. So if you try to have a high jump shot, it hits the ceiling. It's true. Justice White calls this, quote, raw judicial power. Raw judicial power. And he says at the end something very interesting. He says, maybe the court can get away with this, right? It doesn't make it right. Maybe the court can do this, but that doesn't make it right. And this is a theme of legitimacy that is the centrality of the holding in Casey, right? The mere fact that the court can write this opinion and then the New York Times puts this headline out and then 50 states change their abortion laws, the mere fact that this happens doesn't mean it's good. Does not mean it's good. And Justice White would have people question whether we should have such an extravagant exercise of judicial review. Scotty?
Was that right? White or Rehnquist?
I'm talking about White.
Okay.
It's White, right? I think it's White. Okay. Okay. A somewhat funny story, but one of my law school professors told a story once where he met Justice Blackmun in his later years of his life, and he was wearing a T-shirt. And this is long for emoji, but he had on one side a rowboat, and the guy, swimming in water. There's a V in the middle. Roe v. Wade. You can text that later. You can figure it out. There's actually this blog recently that had SCOTUS emoji. I didn't get them. I don't understand this stuff. I think it's beyond my ken. I'll put it up and show it to you. But there are these graphic depictions of Supreme Court cases. Okay. Questions on Roe? Any questions on Roe?
So I think Hillary Clinton said the other day that the unborn do not have constitutional rights to attend public
What did she actually say? I didn't hear what she actually said.
said that the Constitution does not stand to.
As a matter of under Roe v. Wade, yes, that's correct. So here actually the SCOTUS emoji. So this one is easy. I want to figure out number 5. Yeah, there it is. Brown against Board. Oh, folks, education. So it's all these scores of education. This one I don't get. This is Roe v. Kanye West, but it's Roe v. Wade. I don't understand. I don't understand that one at all.
Oh, Dwayne Wade.
Is that Dwayne Wade? Oh, it looks like. Oh. I didn't know the Kanye West Dwayne Wade emoji. Okay, you're right. And this one actually is really good. This is Kilo versus New London. Yeah. So the city of New London. That one. These are hard. Anyway. Oh, this one's really hard. Marbury against Mad Sun. Oh. Bury the head in the sand versus Mad Sun. Awful. All right. So any questions on Roe with the emoji? Other than my poor emoji skills, I suppose. Someone actually wrote the book Moby Dick and Emoji, the entire book. They actually crowdsourced it. I don't know. You're going to law school instead. So any questions on Roe? So what happened after Roe? So we already discussed there was this backlash, and Samuel, I think, alluded to it. There was an evangelical backlash. And for whatever its motivations, state one after another tried to enact various laws that tried to, if not circumvent Roe, push Roe to its limits. And they tried to impose various regulations during all 3 trimesters to make it harder for women to obtain abortions. So there were a couple cases involving, one was called Planned Parenthood versus Danforth, which discussed a law requiring the father to consent to abortion, and then the court invalidated that. There was another one called Bellotti v. Baird. This is a law that prohibited minors from obtaining abortions, but the court invalidated it unless it had what's called a judicial bypass. That is, if the minor goes to a court and says, I can't tell my father because there'll be abuse, then the court can allow the abortion to go forward. One of the few cases that the abortion rights groups lost was called Harris v. McRae. There was actually a challenge saying the federal government funds childbirth, but they don't fund abortion, and that through Medicaid and other federal government fundings, they have to subsidize abortion. And the court held no, that the government is not required to fund abortions. There were cases involving waiting periods, which were invalidated, saying that you couldn't make someone wait 24 hours before providing an abortion. This was a case called Akron versus Akron Center for Reproductive Health. And there was another case, Webster in 1989, that upheld a law that forbade abortion at state hospitals. Okay. Now the thing about Webster was that it was 5-4. But Justice O'Connor didn't actually join the majority opinion. She kind of concurred in judgment with a wishy-washy O'Connor opinion. Justice Scalia took her to task and criticized her, saying, hey, wait a minute, you've voted against all these other abortion laws. Why are you getting cold feet, Sandra? And it was known that this opinion really affected O'Connor and made her very jaded on the issue. Okay, so Webster was in 1989. What happened after that? By all accounts, after 1989, the writing was on the wall that Roe v. Wade was likely going to be overruled. The votes were there. The court was leading in that direction. President Reagan had just appointed a bunch of new justices. You now had President George H.W. Bush, who would probably fill a couple of vacancies. So everything was looking as if Roe was going to return. What happened next is the stuff of Supreme Court legend, and is proof of why SCOTUS nominations matter so much, which is a testament to what's going on in Washington now. So in 90, or I think it was 90, Justice Brennan retired. He basically couldn't do the job anymore. He was very sick. He was hoping he could live and be replaced by a Democratic president, but he could not live enough. He actually ultimately did live another 4 years, but he didn't think he could. So he retired from the bench, and he gave to President George H.W. Bush the chance to replace him. Now think about this. This is Brennan, the liberal line, who made all these opinions that law students and law professors revere as gospel. And now a Republican president could replace him. So what happened? A couple years earlier, President Reagan had nominated a man named Robert Bork to the Supreme Court. Robert Bork was a strong conservative, a Yale law professor, worked in the Nixon and Ford administrations, and was a very proud judge. And the Democrats freaked out and said, we can't confirm this guy. If we confirm this guy, Roe v. Wade's gone. So Senator Ted Kennedy gave a famous speech where he said, if Robert Bork is a justice, women will go back to back alley abortions. He gave this very passionate speech. And Bork's nomination was defeated. So then after Bork, President Reagan nominated another guy, Douglas Ginsburg, who was one of my law professors in law school. The reason why he was my professor was he was never confirmed. It turned out that Doug Ginsburg had smoked marijuana with some students. Now, back then, that was a disqualification for a job. Today, it's probably a qualification. So Ginsburg was never actually formally nominated, withdrew. And then Reagan, desperate, went to Plan C, a guy named Tony Kennedy, who is your supreme overlord, who decides all things right and wrong in this world. And Kennedy was confirmed almost unanimously. George H.W. Bush then had a vacancy a few years later to fill the Brennan seat. He did not want the fight that Reagan had over Bork. He didn't want to put the fight. So the strategy was, let's put a stealth candidate through, right? Let's put a stealth candidate through. Someone who will just slide in there, twice one class. Someone who will just get into the seat without raising any hackles and be confirmed without a big fight. Like, you don't want to waste the capital. So they selected a guy named David Hackett Souter, a bachelor from New Hampshire, who had been a Court of Appeals judge for about a couple months, very, very short period of time. Souter had no meaningful record, but Bush's advisor said, oh, God, trust us. This guy's a conservative. He's going to be rock solid conservative, rock rib. And then he was confirmed. 1 year later, Thurgood Marshall had to retire. He, too, was sick. He couldn't live any longer. So H.W. Bush could replace Brennan and the icon Marshall, right? So for the Marshall nomination, he nominated Clarence Thomas. By the way, there's an HBO movie going on right now called Confirmation with Kerry Washington. It's not a documentary. It's basically not quite a work of fiction, but close to it. They basically make up a lot of the dialogue and a lot of the scenes. And there's actually a disclaimer now, because of threats of libel lawsuits, that says this is not actually history. This is fictional recreation. But the Thomas nomination was an absolute train wreck, because the liberals again realized, and the Democrats realized, if we let this guy through, Roe v. Wade is in danger. So they tried to block him, these confrontational hearings. Eventually, Thomas made it through by about 2 or 3 votes. Okay, so now we have a court with Brennan and Marshall replaced by Souter and Thomas. And by all accounts, it looked like there maybe were 6 or maybe even 7 possible votes to overturn Roe v. Wade. 6 or 7 votes to overturn Roe v. Wade, depending how you count. This case was a milestone. So the Planned Parenthood lawyers who brought this decided, look, we have to go all or nothing. We can't do this thing where we have these little things here about parental notification laws, about consent, about this. We have to go straight up. And they asked the court, are you going to overturn Roe v. Wade? That was actually the question, right? Do we overturn Roe or what? What happened next is the stuff of, again, Supreme Court legend. The case goes to the court, and it's argued. And after the first conference, the vote was, I think, 5 or 6 votes to overturn Roe. After the first vote, there were all these votes to overturn Roe. In shades of what happens in Obamacare, there was a change of heart. And there's this great scene in the book Supreme Conflict by Jan Crawford, where she discusses, by the way, Scalia and Kennedy were neighbors. They basically lived like a couple blocks away from each other in Fairfax, Virginia. And they described this scene where Kennedy and Scalia were going for a walk, outside their houses in Virginia. And Scalia goes to Kennedy, Tony, are we good? I mean, are you sticking with your vote? I heard, that you may be second guessing your vote. And Kennedy says, yeah, we're good, Nina, we're good. two Italian paisans, right? Shooting the breeze. The next morning when they get to the court, an opinion circulated. It's a joint opinion. Now, you've never seen this before except for the NFIB. The opinion by O'Connor, Kennedy, and Souter was a joint. Not one of them signed it alone. They wrote it together. This was like the joint dissent in the Obamacare case. The opinion was circulated, and Scalia was like, what the hell is this? They changed their votes. And rather than being a 6-justice block to overturn Roe, there was now a very fractured opinion. Okay? There was a very fractured opinion. And I'm not going to go to majority. The word's actually plurality. I don't know if you've seen this word. But plurality. Okay? There was a plurality. When there's no single opinion in the Supreme Court that commands 5 votes, as in this case, you call the most narrow opinion the plurality. This is what's the controlling opinion, right? There are only 3 votes there: O'Connor, Kennedy, and Souter. Okay. Justices Stevens and Blackmun, again, same one, no relation. Stevens is in Blackmun, right? Here, I'll write it out so it's easier for you, okay? This is O'Connor, Kennedy, and Souter. Okay. Stevens and Blackmun heard in judgment. We basically have 5 votes altogether that Roe is still good law. So there are 5 votes that Roe is still good law, even though 3 didn't really agree with that, but we'll get there later. So you had 3, you had 2, and then you have Rehnquist, you have Rehnquist, you have White, you have Scalia, and Thomas in dissent. So you could have had 6 or 7 votes to overturn Roe, but the 3 in the plurality decided against that, and they sought to save Roe. Now, Casey is an important decision, not just for its abortion jurisprudence. Casey is an important decision for its discussion of stare decisis. Stare decisis is probably a topic you don't give much thought. But this is the court's probably most detailed discussion of stare decisis ever. They don't discuss it very much. Justice Alito, he gave a speech in Dallas a few months ago that I was at, and I was taking notes. He probably didn't want me to, but I was taking notes. And he said, paraphrasing, stare decisis means we follow the law when we want to. It means we follow precedent when we want to. And I think it's actually, he put it quite well. So the court has 2 major obstacles here, right? First, why are we going to adhere to Roe? And second, even though we're adhering to it, there's certain parts of Roe that aren't really Roe. There's certain elements of the abortion jurisprudence that aren't consistent with Roe. Therefore, we're going to chisel away other aspects of abortion rights to be consistent with Roe, even though Roe said no such thing. So the opinion begins, and you'll find this. You're going to read a bunch of Kennedy opinions next week. He writes all the civil liberties cases the last 2 decades. But the opinion begins. Liberty finds no refuge in a jurisprudence of doubt. Dan, what the heck does that mean? The very first sentence, liberty finds no refuge in a jurisprudence of doubt. What the heck is that? What the hell is he saying there? You have to learn to read Kennedy.
It's hard to find safety or certainty in doubt.
What's the doubt here? What's the doubt here?
Not sure.
Taylor?
Oh my God. The way I understood was.
You all right out there?
The way I understood was that where there's not a
consensus or a agreement in this holding, or in not this holding, but in the doctrine that the future liberty of the issue is.
What does this mean? Jurisprudence of doubt. What does that mean? What does jurisprudence mean? So what did jurisprudence of doubt mean?
I guess he's talking about how they basically just made stuff up, not made stuff up, but kind of just developed their way through Roe.
So we can't, change the law as quickly.
Yeah. Yeah, exactly. Liberty finds no refuge in jurisprudence of doubt. In other words, people can't be free if you're always changing the law. Is that what you were?
Yeah.
People can't be free if the precedence, the jurisprudence is unclear. The primary theme of this opinion is we need people to be confident and certain that the law is what it was and that we're not going to change stuff for other reasons. And he's talking, I keep saying he, this is Kennedy. You learn their writing style. Very often the justices have unsigned opinions and it's a parlor game trying to just guess who wrote it. This is Tony all the way. Not all of it is. Some of it's O'Connor, but this is Tony at his finest. So it's with this background that the court considers this Pennsylvania abortion law. There are several procedures in this law. First, women must be given informed consent. Okay, that's not too controversial. The second one is a bigger part. You must provide this information 24 hours before the abortion. In other words, the doctor gives us literature, and then you have a clock. You have to wait a full 24 hours before the woman can obtain the procedure. Third, there is a law for minors. They can't get it, but there is a judicial bypass if the minor can't obtain the consent. The fourth provision is that under certain circumstances, with certain exceptions, the woman must obtain the husband's consent if she's married and she wants to obtain an abortion. There are exceptions for things like physical abuse, or if the husband can't be found, or things of that nature. Not psychological abuse, though. That's a big point the court stressed. That's O'Connor. That's all O'Connor, that portion. So, at the outset, the court says, we are reaffirming the central holding of Roe. Now, Lara, I showed you the press release before. What was the holding of Roe? I mean, it was pretty clear when you read it. What was the big holding of Roe, the press release?
Basically, that the states couldn't interfere in the first 2 trimesters of pregnancy.
Well, they couldn't interfere at all during the first.
Right.
And what during the second?
Only in health matters.
For the second. Good. And what the third?
And then the third, basically, they couldn't at all.
Whatever they wanted, right? Yeah.
Right.
Okay. That was a holding. You guys, you read it. I mean, it was bolded, made it really easy for your notes, I'm sure. But here the court, how should I say, reimagines Roe. And they say there are 3 components of Roe. The right of the woman to choose to have an abortion before viability, without undue influence by the state. Before viability, the state's interest is not strong enough to prohibit it, or impose substantial obstacles. Wait a minute, what just happened here, right? What just happened? Something changed, right? It's a glitch in the matrix. Roe was about trimesters. Here, the line is viability. Your eyes do not deceive you. That was not the line in Roe. It wasn't. I mean, we could argue about this all day, but it wasn't the line. Also, if you notice, it says you can't impose substantial obstacles. That means you can impose non-substantial obstacles, right? The idea of an undue burden test, which is where we're going in a few minutes, you can impose burdens. It just can't be undue. This is totally different than Roe saying you can impose nothing at all during the first trimester, and then for the second trimester, only for the mother's health. Here they're saying before viability, you can impose an obstacle. It just can't be, substantial. And by the way, we get these 6 month, these 3 6 months. Now we have one line viability. What's your hand up, Tam?
Yeah.
You just mentioned that viability was not the line in Roe, but didn't Roe help define viability?
By the trimesters, right? But what's interesting here is that viability is a function of science, isn't it? Whatever neonatal care was in 1973 is different than neonatal care in 1991. And today it's even, I mean, does anyone know what the youngest infant NICU can survive? I don't know the answer. I'm guessing it's earlier than it was in 1990. Is that a fair? So, I mean, what the court's doing here is saying, look, this trimester thing is silly because we've advanced science in 20 years. So they're redrawing the line of viability. Right? So in the 20 years as science was progressing, the line was still the trimester. So here they're saying, oh, well, based on viability. Okay. The second holding of Roe, as imagined by the plurality, is that the state's power to restrict abortions after viability, right? They have this power, right? So long as there's, protection for the mother's health. In other words, after viability, the state can ban it altogether, so long as there's exception for the mother's health. But the key point is the third one. The state always has an interest in the life of the fetus. Notice they don't say the potentiality of life. Not the potentiality, the life of the fetus. And again, they're not talking about a person for purposes of the 14th Amendment. The 14th Amendment is irrelevant here. They're saying the life of the fetus. They say the principles do not contradict each other, and indeed they're consistent. Okay? So I want you just to pause for a moment and recognize what the court did. They rewrote and effectively overturned Roe. There's, no matter how many times they repeat over and over again, we're reaffirming Roe, they're reaffirming it in name only. This is why if you ever go to an abortion protest, they have the sign saying, save Roe v. Wade. And now you're like, hey guys, Casey overturned it, right? You'll be one of those guys. But it was such a monumental case that everyone knew the name. If the court had come out and said, oh yeah, we're overturning Roe, but putting something very similar to it, it would have defeated the entire purpose of what they're trying to accomplish. So they said, look, we're upholding Roe, we're just rewriting it. Okay. And the court actually tries to put it on some of a solid footing. They talk about the due process clause. They talk about the various liberty interests. My favorite quote. This is Kennedy at his finest. He says, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." I don't know what that means. Actually, it's funny. Last semester, maybe a year ago, I had a student who was a theology major, and I swear to God, this is actually a paraphrase of a speech from Pope John Paul II. It's actually a paraphrase from one of John Paul's teachings that's in here. It's awfully close. So I had no idea, but a student told me about this about a year ago. So we have that. So the actual test, right? The actual test that they impose, again, Roe was strict scrutiny with a fundamental right. We do not apply strict scrutiny under Casey. They make up a new test, as if you needed more tiers of scrutiny, right? They make up a new one. It's called the undue burden test. The undue burden test. And the court defines it by saying that the state cannot impose a substantial obstacle for women having access to an abortion. Note, it's not strict scrutiny. It does not mean that the government always wins. Call it maybe intermediate. I don't know what you want to call it, but it's this undue burden test. And this is the framework the court now applies. Okay. I'll get in a minute how the court applies it, but I want to talk about stare decisis first for a few minutes. So the thrust of the stare decisis discussion is that the rule of law requires continuity. The rule of law requires continuity. And he makes a few points. First, he says, look, women have come to depend on it. Those are what are known as reliance interests, that for 2 decades, women have known that the intimate relationships they make are made against the backdrop of an abortion, that if they so need it, they can get it. They say, quote, An entire generation has come of age, free to assume Roe's concept of liberty, defying their capacity of women to act in society and to make reproductive decisions. No erosion of principle going to liberty or personal autonomy has left Roe's central holding a doctrinal remnant. So effectively, women have depended on this, and that's like the centrality of their, economic existence. Okay. The court makes another point. This is actually Dan's question before. We've also learned that the rigid trimester framework, they're calling it rigid, right, doesn't actually make sense anymore because viability has changed. Okay, time limits have changed. So instead of trying to base this on some notion of trimesters, they're going to base it on viability. What is viability? We don't know. And the court's actually still grappling with this. How many weeks is viability? This is a still lingering issue. But then they make another argument, which I think is the most profound one. Roe v. Wade was 7-2. Ostensibly, when this case was first argued, Casey, it was 7-2 the other way. What was the difference between the 7-2 majority in Roe and a 7-2 majority in Casey? Ronald Reagan, George Bush. And the point the court's saying here is, look, if the only reason that we're overturning this case is because now there are more conservative justices, it will make our court look bad. It will make a court look bad if we're only changing this because the composition of the court has changed. And this is a profound point that you should all be thinking about, especially with the SCOTUS vacancy. Precedent, to some degree, matters to the justices. And let's say Merrick Garland gets confirmed, and then the Second Amendment comes up. Does the court vote now to overturn District of Columbia v. Heller and say there's no Second Amendment right? There were 4 justices to do it for sure in Heller. There were 4 justices in dissent to McDonald. Will there now be 5 to overturn Heller? Or will they do what they did here and say, we're upholding Heller, we're just going to limit it. We're going to read it more narrowly, right? We're going to just hollow out the entire court and say, oh, it's only about handguns, nothing else. This is what judges do. They very seldom overturn a case outright. Instead, they say, oh, we're upholding the core of this, but we're just going to, like an orange, just hollow out the middle and give you the shell, right? The court also discusses the legitimacy of the court. We discussed it with Obamacare, right? How would the court be attacked and criticized the overturned decision that they deemed as important as Roe v. Wade? And they're very much worried about this legitimacy. Okay, they say they would subvert legitimacy beyond any doubt. Okay, so let's walk through each of the actual Pennsylvania laws. So the first one, right? The first one concerns the 24-hour waiting period. Now, mind you, the court had already overturned that several years earlier. They reversed that precedent. No one's ever heard of Akron. Everyone heard of Roe. So they overturned the Akron case. They say, look, this is an important decision to make, right? What's the big deal about waiting 24 hours, right? We're giving you this literature to read. Take your time to read it. Now, the other side argues that, well, for perhaps women who are poor, they can't afford to have a hotel. They have to travel there and back, go to work. So this doesn't pose a burden. But the court upheld the 24-hour waiting period. This is indeed an issue currently in Texas because a law that Texas passed could have the effect of shutting down various clinics throughout the state, requiring women to drive significant distances. So this exact issue is currently before the court. And maybe we'll see a decision this semester, although I doubt it. The second provision was invalidated. This provision concerns notifying of a husband. And this was an O'Connor. She wrote this. And she said, look, very often the case is that the reason why a woman is getting an abortion who's married is she doesn't want her husband to know. And although the statute allows for an exception for physical abuse, it doesn't allow exception for emotional abuse. And indeed, doesn't allow exception for child abuse, if perhaps a father's abusing the children. So the court invalidates that one. The parental notification, though, was fine because they had this sort of bypass provision. Okay. and then they close. Our Constitution is a covenant running from the first generations of Americans to us and to future generations. Each generation must learn anew that the Constitution's written terms embody ideas and aspirations that must survive more ages than one. We invoke it once again to define the freedom guaranteed by the Constitution's own promise, the promise of liberty. All right. Questions on the majority? I keep saying majority. It's not the plurality. In Casey, yeah.
I'm sorry, I think I'm backtracking a little bit. But,
That's okay.
So with the court deciding the viability is the new test, with the understanding that advances in medicine and do change, would it be fair to say that they pretty much kind of passed the buck?
Yes, exactly. That was my next point. Exactly right. What the court is doing here is delegating to the legislative branch to decide when viability is. You can update viability by statute. You can't update trimesters by framework, right? 3 months is 3 months is 3 months. But if it's viability, maybe in 15, 20 years, the new device is invented that can keep babies alive at 18 weeks, whatever it is, right? Well, then the legislative branch can figure it out. They were, okay, second, John. They were delegating this decision out to the legislative.
So the life of the fetus part of this, does that contradict or conflict with the 14th Amendment?
It's independent of the 14th Amendment. It's certainly true. It's certainly true that under the 14th Amendment, a fetus is not yet born, so it's not a citizen.
Yeah.
But that doesn't mean the police power doesn't cover it, right? The states have police power to affect the health, safety, and welfare beyond what's in the 14th Amendment, right? The police power pre-exists in the 14th Amendment. So the state has an interest in life totally separate and apart from the 14th Amendment. That's why it's Hillary Clinton's comment irrelevant. The state doesn't argue with the 14th Amendment.
They said that they upheld the vote, but the reality didn't.
They carved out the middle, yeah. They basically hollowed it out like an orange.
What's the practical difference?
Well, the practical difference is huge. Now the state can actually pass laws regulating the life of the fetus before the third trimester, right? Now the entirety of the pregnancy, right, the entire 9 months, the state can pass laws with the life of the fetus in mind. They cannot do that in their own. Yes, now viability can actually put regulations further up. Because as viability gets closer to conception, the state has more room to regulate. Okay. Justice Stevens, basically said he'd reaffirm Roe in its entirety. Justice Blackmun, who by this point was about a year or two from retirement, he held on until Clinton came in office and retired very briskly. He was replaced by Justice Ginsburg. He basically makes his point, which is actually almost surreal. But he said, look, I wrote this 25 years ago. I'm not going to be around for a long time. My replacement is going to have to replace me. And the next confirmation hearing should consider how my replacement will vote to uphold Roe. He's basically like, trying to endorse his replacement, make sure his replacement is a liberal. It was Ruth Ginsburg who voted that way. But it's a strange dissent. A funny story. Justice Blackmun, when he was on the bench, he would often doodle and write notes about people, and he would grade the advocates. And when Justice Ginsburg argued a case in 1973, he wrote, NYCJ ACLU, very precise, reads, Rutgers. You want to guess what NYCJ means? You're laughing.
No, I don't know.
New York City Jew. And he gave her a C+. Hispanic lawyers were labeled H, and Jewish lawyers were labeled J. He had a system of notes for all these people. He was interesting. So Justice Rehnquist wrote a dissent, and he said that, again, this retains the outer shell of Roe, but it basically hollows out the middle. And he makes an important point. He says, look, the court keeps saying, we had Plessy was overturned by Brown, right? And Brown was good. And then we had Lochner overturned by West Coast Hotel, and West Coast Hotel was good. But the point that people may miss is that what made Dred Scott so bad, and what made Lochner so bad, apparently, is the court was making up rights, both under the Due Process Clause. Dred Scott made up the right to hold a slave, and Lochner apparently made up this right to liberty of contract. What Scalia and Rehnquist say is, wait a minute, which is the bad precedent here? It's Roe that made up this right to abortion. So basically you're saying you're sticking with the wrong precedent merely because it's precedent. And the court says that can't possibly be correct. And Scalia, as I noted earlier, closes with this image of Tawney, where he directly compares Dred Scott to Planned Parenthood versus Casey. And Scalia says, Dred Scott didn't end the controversy over slavery, and Roe did not end the controversy over abortion. And in the 25, 26 years since Casey, the debate over abortion hasn't come close to ending. It's spread into other areas like the contraceptive mandate, with the illicit of the poor, and Hobby Lobby, in many other areas. And the court has a Texas case this year. So this case did not purport to resolve everything that came after. Go with a minute left. Questions? Yeah. Well, what Kennedy, O'Connor, and Souter mean is for people to respect the rule of law must be constant. If the law is constantly changing, people will doubt its legitimacy. They think, oh, the reason the law is changing is because now these Republican appointed judges and not Democrat appointed judges, and that will harm legitimacy before. Think of that very carefully if the next justice votes to overturn Heller, and votes to overturn Citizens United, and whatever else. Now, you're going to read a case for next class, and I'll end with this, called Lawrence against Texas, also written by Justice Kennedy. Lawrence v. Texas overturned a case from 10 years earlier, Bowers v. Hardwick, which said you could have bans on sodomy. Justice Kennedy ripped him saying, wait a minute, didn't we just say precedence was important? How can you now overturn a precedent? Did we just say we have to have people relying on us? So pay close attention to Justice Scalia's dissent in Romer. It's one for the ages. Thank you very much.